Looks like we have quite a few documents to catch up on. Hey guys, this is Jules with True Crime Reactions. I'm sorry that I'm a little bit late getting these documents out, but there's been some other videos that I have wanted to get out, some other cases that I've been looking at, some other subjects that I have been addressing. It's 110 right now in Texas, and I literally just cannot deal with it. So if I look a little sweaty, it ain't my fault. But it looks like right here in this 5th supplemental request for discovery that it's pretty much just vague and a blank, and everything that was attached to this is now completely under seal. And if we click on the 6th supplemental request for discovery, it looks like it's the exact same situation. Now, this is a stipulated motion to file. Let's take a look at this. Okay, so this is just for the attachment that we've already seen be sealed and redacted. So yeah, this is basically something that we've seen in the other one. Order to file, exact same thing. It is for the sealing of the attachment to this supplemental request. And I'm pretty positive these are the same things, but for the 6th one, yes, all the exact same stuff. So let's look at this order to seal right here. This is concerning a Zoom meeting, but it's interesting to me because we have this subpoena ducis tecum thing, and I might not be saying that right, but that's fine too. If you look at the definition of this, it's like somebody has to bring something with them. A subpoena ducis tecum is a court summons ordering the recipient to appear before the court and produce documents or other tangible evidence for use at a hearing or trial. So it's really curious to me not only who this could be for, but what they were supposed to be bringing with them. And again, there's no specific information. It's just about whatever this subpoena ducis tecum is about. I don't see. Yeah, state seeks protection pending a hearing on this matter. And this is dated when? See, this is dated May the 26th. So this would have been before that court hearing on 6/27. Let's see. Is there anything else specifically on here? It seems like different things happened on this one on different dates in April. And something else that I noticed about the documents is that most of them originated around the time that we heard that the private investigator for Ann Taylor had released information about Bethany having possible exculpatory evidence for Brian. All of this pretty much is like from that time frame. Now, these documents here, these search warrants, are extremely interesting to me because not a single one of them is for the suspect. Not a single one of them is for Brian. Now, this one right here is for Meta, which, as most of you guys know, would be Facebook and Instagram. But I'm pretty sure this one is specific. This one is specifically for Instagram. And it was obtained on April 19th, served on April 20th, and on May the 12th is whenever they received the information. Okay, this is the one. Now, I want to thank a little YouTube channel, and I say little because she doesn't have very many subscribers, and honestly, she needs a lot more. And that's just my personal opinion. I'm going to have a link to this video and her channel in the description box. But there is a YouTuber that goes by the name of Crime Sleuthin', and she jumped up on Dago's panel. Today is Tuesday, on Monday, and she brought this to our attention, and I'm glad she did. And I'm here to tell you now. I know that there were some creators that went live or did videos late last night about this exact information that I'm about to relay to you. But when it comes to me and where I got this little clue from was from Crime Sleuthin', and it was yesterday in Dago's live. I do not use Reddit. I've maybe made one Reddit post, and it was regards to this case where I was asking a question about something. And honestly, I think I maybe checked back on it that same day that I posted it, and I've not been back on Reddit sense for myself. So I don't have any reason to recognize the way that the username format is. Okay. Right here where it says you, and then obviously it's just you with the little thingy, the diagonal. I'm like at a loss for words for what that's called, but you know what I mean? The slash. Okay. That is the format for the beginning of a Reddit username. So what they did here, and I don't know if they've figured this out or not, or if their teams that get on YouTube and see what we're all talking about is going to see this for the first time. But what they did here was submit a Reddit username to Instagram. And it came back, no data received. Well, that's because you submitted the wrong information to the wrong social media platform. So I do want to thank Crime Sleuthin for that again, because I don't use Reddit enough to even notice that. So it's interesting that they made such a big mistake like that and then still felt the need to put it in the records. Like, once you realized you got it wrong, why didn't you go back and fix it? I don't know. Anyway, it's only for Xana and Madison from June 23rd to November 21st. Now, November 21st, as you guys know, is Brian's birthday. And it's also well over a week after the crime, or about a week after the crime took place. And the June 23rd, 2020 date, if I'm remembering correctly, is the date that they're claiming that Brian's AT&T phone line that they are using in the searches for the search warrants and stuff for his identifying phone line was opened on June the 23rd. So I find it interesting that it's just for those two, for those dates. Now, I know that they are trying to go back and get information for multiple dates. It seems like different segments of dates are being searched for, but we're not seeing correlating search warrants for Brian when it comes to any of this, which is, again, it's extremely interesting given the fact that we've been told that there's no connections between the two. I mean, between the five, there's no connections. Now, this one right here is from Meta again. And you always just want to scroll all the way down until you see a page that looks like this, because everything else is just the same legalese, and it's completely pointless to just keep reading over it again. Now, this one, again, this one is for Facebook. This one was served on April 3rd. And on April 26th, they received an email directing them to the data file download, and they downloaded everything on May the 2nd. Now, this one has 6 names that they're looking for on here, with no specific other information besides that on that portion. Now, this has, again, from June the 23rd. Now, this one goes to August 1st. That's only like, what, a month and a half? Only a month and a half. Now, it's for Madison and obviously Dylan and Bethany, for Kaylee and Ethan, and then for Xana. So it is for, is anybody missing in this? No. 1, 2, 3, 4, 5, 6. No, nobody's missing except for the suspect. And I'm still going to say this. I find it interesting that they, months and months after his arrest, decided to go back in and get warrants for this stuff. And not a single one of them has anything to do with Brian, because this one is again for Instagram, served on the 3rd. And then on May 9th, they received an email directing them to log into the portal to download the data. And this one was for 1, 2, 3, 4. But then this one right here states not received. And then let's see if there's any more. So this one is for Bethany, Dylan, Ethan, Xana, Kaylee. Nothing for Madison on this one. And again, from June 23rd through August 1st, which is, again, only like six-ish weeks, right? Yeah, something like that. The last week of June, and then all of July, and then pop, it's August 1st. So not even a month and a half, 5 weeks, 5 weeks-ish. And now we have this one from T-Mobile, and I have these written down because this one should be for Kaylee and an unknown, if I have this right. T-Mobile. It was served on March the 30th. And if you see right here, it has 2 different phone numbers. And if I wrote this down correctly, the 4818 number is Kaylee. I don't know who this number is for. And this is also from June 23rd to August 1st. just a little 5-ish week period. So this one was served to Verizon on April the 3rd. On May the 1st, they received the email with the information. And if you look right here, the 3185 number is the unknown number, and the 1841 number is Ethan's. And look again, 5-week period. Some people are questioning if this is like an Apple Watch. There was a conversation. I don't know anything about Apple, you guys. I'm Team Android all the freaking way. Team Android. I don't know how the Apple stuff works. So if anyone that actually knows for positive, like if any one of you amazing people out there that watch these videos of mine happen to work for Apple or work for a cell phone company and they know this answer for sure, do Apple Watches have like their own phone number? Or is it all connected to like the main phone number for your account? Because I've heard yes and no on that. And I'm, like I said, I'm Team Android. So I honestly have no idea, but it would be kind of interesting to get the answer for that, because some people are maybe like assuming that it's not really like an unknown person, but that maybe it's an Apple Watch number. But I'm questioning that theory, because if it was the Apple Watch number, it wouldn't be listed as an unknown, I guess, in my opinion. I don't know. Okay, so now we have this affidavit of Rylan L. Nolan. Now, from what I'm understanding, this person is an employee of the Idaho State Police Forensic Services Laboratory in Meridian. The only thing about here that I really care about, because I don't honestly, because I'm not a lawyer and I'm not battling this in court, I don't care about none of this person's like background. The only thing that I cared about is this right here. I affirm the ISP Forensic Services Biology DNA Casework section does not require submitting agencies to notify the laboratory how a suspect/subject was identified in a case. So this is something that the state must have had done in order for them to be able to combat the fact that all of the genealogy workup is wanted by the defense, which is fine. They have every right to do so. But I still stand by my opinion and the opinion of several professionals that I've seen talking in mainstream media and on social media about this, that the genealogical workup of this is extremely important to the defense. I feel like if it was you that was on death row, basically, because you're about to be convicted possibly and put on death row, you would want every little smidget of what they did on a workup on you to say that you're the guilty person. And if you can sit there in your chair or in your car or on your couch or laying in your bed and listening to this right now and tell me that you wouldn't want every little detail, you're lying. It goes on to say how a suspect/subject was identified has no effect on the laboratory analysis performed on the known reference sample from that individual. It also has no impact on the statistical calculations performed when doing a direct comparison of the reference sample STR profile with the STR profile developed from the evidence sample. But the profile that was developed from the evidence sample, I'm not going to say that there's a possibility that maybe they calculated the sample incorrectly, because I don't feel like that would be the case here. I just don't feel like there would have been a good enough sample for them to have even gotten any work off of, especially if it was something like touch or transfer that was deep seated in like the very pits of this little bitty snap thing on metal. The metal itself is a big issue with the stuff that I've been learning here lately. The type of metal also matters in that whole situation. And that's something that we're going to go over. But I found it very interesting that they now have this lab person coming out here and giving all of their credentials and all of their experience to fit the state's narrative. But whenever it came to the defense wanting all of this information about the professionals that worked on the case and did all of this work, the state was like, oh no, you don't need any of that. You don't deserve any of it. So they're only okay giving out people's information whenever it benefits them. And that's not very fair. Okay, now we have this motion to temporary seal stipulation and order regarding return of evidentiary items pending a hearing. This must be the hearing that I got an email for last night. That's going to be happening on August the 2nd. Yeah, evidentiary items. I'm actually really interested in that hearing because I saw a document with some handwriting on it that I'm waiting to get to here that I was super curious about. So it says temporary order sealing the stipulation to amend order regarding return of evidentiary items and second amended order regarding removal of evidentiary items for forensic evaluation. And all of this stuff is going to be sealed. Reply in support of motion for protective order. This is 19 pages, and I am not going through all of this. The state submits this reply to address several of the defendant's arguments in his objection to state's motion for protective order, as well as the two declarations filed by defendant in support of his third motion to compel discovery. And this is about the IGG information. The state still states that they do not need to disclose anything about that whatsoever. The state explained in its motion why subsections all these numbers and letters and all these other numbers and letters do not apply to the IGG information. Defendant objects on the basis that the IGG information falls within subsections, all these other numbers and letters. Defendant's assertion do not withstand scrutiny. First, defendant badly asserts that the IGG information rather obviously falls within the ambit of Rule 16b-4, but fails to explain how that conclusion results from the language of the rule. Okay. As best the state can tell, defendant is not asserting that B or C apply to the IGG information. So A is are material to the preparation of the defense, which in my opinion, and in the opinion of lots of other people, it is, are intended for use by the prosecutor as evidence at trial, or were obtained from the defendant or belong to the defendant. So what this states right here, the defendant is not asserting that B or C applies, okay, but it still applies to A in most people's opinions, or at least in a lot of people's opinions. Presumably, then, defendant was attempting to show that the IGG information is material to the preparation of his defense when he asserted that someone other than the defendant may have placed his DNA on the K-bar knife sheath. I mean, yeah, that was they're not wrong. That was the wording. But the state is at a loss as to how that theory supports a claim that the IGG information is material to the preparation of his defense. The S&P profile used in the IGG was created from the same DNA used for the STR analysis, and the state is providing the S&P profile and information related to the STR analysis in discovery. Okay. I mean, that's good that the state has that part at least. If defendant wishes to explore the theory that his DNA was planted on the K-bar knife sheath, he is free to do so. But the family tree created by the FBI has no relevance to that theory. But it does, though. Like my kid. But it does. But it does. Because if the defense is going to sit here and claim that the K-bar knife sheath with said DNA on it was planted, then the genealogy tree technically would still matter. Because you should want to see and you should be freely willing to give any and all information that you have if you know that it's valid. So if you know that it's valid, I don't understand why we have to play all these pissing match games. Just give it to him. Oh, wait, you can't because the FBI doesn't even have it. So in reality, this argument is just that the state doesn't have this stuff. So I feel like they're just going to use all the legal tactics that they have to try to get out of having to give it over. Because in my opinion, if it's valid and you got it, just show it to them to shut them up. Defendant attacks an argument that state never made. He claims the state argues that if the STR testing is accurate, then there is no reason to concern ourselves with how the state came to investigate Mr. Koberger. But for purposes of this motion, the accuracy of the STR testing is beside the point. The state referenced the STR testing in its motion to demonstrate the difference between the STR analysis and the SNP profile used to conduct IGG. The difference is not one of of degree, but of kind. The S&P profile and IgG was used to develop a lead, not to demonstrate substantive evidence of guilt. On the other hand, the STR analysis is substantive evidence the state intends to use at trial to prove its accusations against defendant. But see, that's my thing here. Like, I understand what they're saying. Like, I really, 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 really do. But I still don't comprehend, like, if you know for a super fact that it's just concrete and valid, then why spend all of you guys' tax dollars on this stupid argument? Like, I almost don't even want to read a lot of this anymore. And I'm telling you guys, I'm not on like a cop hate rant or an LE hate rant or the prosecution hate rant. If they do something, they get their kudos from me too, okay, with the way that my brain works and the opinions that I have. But I feel like if they've got it and it's concrete, then why are y'all wasting so much time with this? Defendant does not have constitutional right to discover all aspects of the investigation. And see, I don't agree with that. I don't agree with that. The court can use the process explained in the state's motion to verify the IgG information does not contain exculpatory evidence. Okay, but unless you're showing them all of the details, then they can't verify that. And that's just the truth. They can't. The declarations submitted by defendant do not make the IgG information discoverable. And I mean, look, the prosecution can like believe whatever they want to believe, and they're going to fight whatever fights they know that they need to fight. But at the end of the day, the judge is the determining factor here. And just like the state didn't want to hand over the training records of those 3 officers, Judge was like, "Oh, no. She made all the valid points. So you got to give them over." And now they've got them. So, they can argue this all they want to, but at the end of the day, okay, and this is just an example that they used in their paperwork. At the end of the day, the judge makes the decision. And if the judge deems that, in his opinion, what he's being told is reason enough, then he'll grant it. And just like if it was a whole completely different judge and they heard all the reasoning and in their opinion, on their perspective, they didn't find it valid, they'd have every right to keep the denial. But again, this is really like the judge's perception here, really. Oh, here it is. Okay. Temporary order sealing stipulation, an order regarding returns of evidentiary items pending the hearing. And this is what's so interesting to me, because this is now being like scheduled for August 2nd. And I'm going to go ahead and do this right here so that you guys can see this a little better. Judge signed this, and it looks like it's his handwriting right here. The court has concerns about transport of items. Now, what I'm curious about here is something that I've already discussed here on this channel. And it's about the blood evidence samples that were taken from Brian Kohberger's apartment that were not left and tagged and put with the rest of the evidence that was taken, but was mishandled by Dawn Daniels for at least 10 days before she herself met up with Ann Taylor at Brian Kohberger's apartment 10 days later and handed her over the evidence and explained the situation to her about why it was not with the rest of it. So I'm wondering if that's what this is actually about here. Now, this is a motion for scheduling order. I'm not sure exactly what this is all about. It says deadlines for completion of discovery by both the state and the defense, deadlines for both parties to make expert disclosures pursuant to ICR, deadlines for filings of pretrial motions and responses of replies thereto, including but not limited to motions of limine, motions relating to the death penalty, and any motions under ICR. So this is a bunch of deadlines that need to be discussed and any other matters to facilitate the orderly progress of this case towards trial. In support of this request, the state notes that trial is scheduled to commence in less than 3 months, and it is necessary and proper that the parties and the court have realistic scheduling deadlines to address potential pretrial issues. Yeah, so that, I wonder if that's going to be the one on the 18th. Let me see if I can find that one. Notice of hearing. See, this one is on August 18th, and it's just a regular defendant's motion hearing. But they scheduled this one afterwards, but for sooner when it comes to the evidentiary items. So I guess we'll find out in, I don't know, 3-4 weeks, I guess. Now we have this motion to reconsider the stay. There was a 37-day stay that was granted, and the state is arguing that, which, I mean, they have every right to. They don't want Brian Kohberger to have any sort of reason for there to be any sort of mistrial by acting like his right to a speedy trial wasn't done correctly. So honestly, right here, they're just trying to kind of cover their bases. It's not enough or important enough. There's nothing special in here for us to like read over this entire document. But from what I'm understanding, that's basically all that it is. The state wants the court to reconsider the stay. But yeah, those are the documents. I find it interesting that they did a Reddit username search whenever they sent it over to Meta. I mean, I guess maybe they didn't catch it either. But I saw some people acting like this could have been like the Papa Rogers account they were trying to get information from. And I would really love to know what about the document made people think that. Which in reality, they just made a really big mistake. So, but that is it for these documents. And hopefully I don't have to play catch up like this again, because I know this video is going to be a little bit longer than what you guys are used to. But that is it. So, see y'all.